These are part-heard appeals in the matter of the Retirement Saving and Welfare Fund of Oil Industry Workers and Crescent Gas Corporation Limited and another.
Yes.
My Lords, my Lady, I was just going to very quickly wrap up on the first respondent's notice issue and then move on to the second. I nearly finished last night, but just a few points to make. First of all, the only cases that CGC praise in aid in support of its invalidity theory are set out in paragraph 84 of its main skeleton. I'm not going to turn them up. It's cases like Gissing and Rossett. They are not, none of them cases where section 53(1)(b) was in issue. What one gets from those are general observations about section 53 as a whole, without where other types of trust were in issue, for example, constructive trust and resulting trust. And we deal with this in our supplemental skeleton at paragraph 38. I won't turn it up, but it's core bundle, tab 25, page 346. I'm not going to say any more about that now. And the same goes for other cases where these points are made by CGC in their supplemental skeleton, such as Austin and Heel, where again it was a common intention constructive trust that was in issue, and we get some general comments. Then we had dealt in our skeleton with the significance of the words manifested and proved in section 7. Mr. Grant has touched on this. Again, I don't want to dwell on it on my feet, but we deal with the drafting history of section 7 in paragraph 36 to 37 of our supplemental skeleton. And that's at core bundle, tab 25, page 344. Well, that's all I wanted to say on the first respondent's notice issue.
Yeah.
And I'm going to then turn to the second respondent's notice issue. My learned friend, Mr. Mumford, and I will divide this up between us. And I'm going to deal first with the authority point. Now, CGC argues that the judge ought not to have concluded that the mortgage documents, that's the deed and the certificate of title, amounted to declarations of trust because the relevant agents of NIOC executing those documents lacked authority to declare such a trust, or it wasn't proven that they did. There are 3 points I make in relation to that issue. First, that CGC is wrong to say that the judge failed to consider whether the relevant agents were authorised. The logic of his conclusion on the declarations is that they were authorised, and we say that the judge was entitled to make such a finding in the absence of any dispute at all on the subject before him at trial. And secondly, as a matter of procedure, we say it's not open to CGC on appeal now to raise this argument as to authority, which is, in our submission, heavily fact-dependent, which could and should have been raised at first instance clearly if the point were being taken. And thirdly, if the matter had been raised at first instance, there are a number of issues which would have had to have been gone into. Including issues of fact. Now, on the judge's findings of authority, CGC says that the judge, so it's paragraph 17 of its skeleton, that the judge failed to consider whether any agent purporting to declare a trust on behalf of NIOC had authority to do so. We say that, on the contrary, we had alleged a series of declarations that we relied on in our amended defence, which included at paragraph 86, subparagraph 9, and then subparagraphs Roman 10 and 11, the 2019 mortgage deed and the 2020 certificate of title. and we allege that those constituted declarations of trust by NIOC. The reference is core bundle, I'm not going to turn this up, but core bundle, tab 20, page 309 to 12, which is where we rely on the series of declarations of trust that we rely on. Obviously, some of those are made before the fund was held to have legal capacity. Now, in responding to an RFI made by NIOC, and perhaps this is important to have this document in front of the court, it is at core bundle, supplemental bundle, tab 2A, and it's page 70.3.
Sorry, give me that again.
I'm sorry, it's supplemental bundle tab 2A, page 70.3. You'll see in A they make the point that we don't say why the documents in question declared a trust in terms of certainty of intention, certainty of subject matter and certainty of objects, i.e. it makes a point about the three certainties not being evident from the documents. And then paragraph B in response to request 3, it says whether or not the documents declare or evidence and express trust, matter of submission in due course. And then C, they make the point that claimant's full entitlement to make submissions in due course on each of the certainties, that's subparagraph 1 in C. 2, the fact that the claimant will resist any application to provide any further information. 3, the claimant's right to require the first defendant to adequately provide particulars of its case.
Sorry, my document presentation screen has gone
The
blank.
document presentation scheme has failed again.
I'm sorry.
While we wait,
It's
it's your
back
point,
now.
it's your point that
Oh.
they don't say lack of authority.
Exactly.
Yeah, that's the point, isn't it? You're just saying that there's a whole raft of answers.
Yes.
They don't include the people who signed it weren't authorised to do so.
Absolutely. Do you have your screens back now?
You've got it back now.
And then you'll see paragraph C, subparagraph 1. It points on the construction of the declarations. Subparagraph little Roman 2, they make the point about some of those declarations predating legal personality. And then if we go over the page to point 4, they make the point Mr. Grant alluded to yesterday about the certainty of object because of the lack of legal personality of the object. And then paragraph 4, this is the point my Lord the Chancellor had in mind yesterday, they make the point about agents not being, as a matter of law, capable of declaring a trust under 53 1B. And that's it. So no indication that a point is being taken on authority. And it gets worse than that, my Lord. They rely on various highly generalised aspects of their pleadings in which it claims to have put authority in issue, but it would be the heaviest lifting done by a general traverse in legal history in our submission. And the key point is this, that there was no challenge to the authority of NIOC's agents made by CGC in its skeleton argument or in its oral submissions at trial, even as late, my lords and lady, as closing submissions. And we say that the judge was, on that basis, entitled to assume that authority was not, in fact, in issue. And if we look just by way of example at CGC's trial skeleton, there's only one round of skeletons for trial, and it's a supplemental bundle, tab 49.
Yeah.
And if we go please to page 433, you'll see that they deal with the English law express trust case extremely briefly, and you'll see at subparagraph A a reference to the legal principles. And at paragraph 129, they say there was no declaration of trust by reference to the three certainties which we saw a moment ago. And then if we go over the page, paragraph 130, they say that an agent's signature will not suffice. And when they come to apply it to the question to the facts, paragraph 131, again, no point is taken on the authority of the agents. And then at paragraph 132, they again take the timing of the legal personality point. And that is it. That is it in the skeleton for trial. The only place in this document where they deal with the two declarations in issue on this appeal, it is at page 424. We go back. You'll see at paragraph 100, they say that the defendants rely upon a mortgage agreement entered into between NIOC, Retirement Fund and Bank Melli. Again, no question of the authority of NIOC to enter into that agreement. Describe NIOC as a party, and no point is taken on the authority of the signatories for any purpose.
No.
And they deal with a certificate of title on the same page, at subparagraph E. See what's said there in relation to the certificate of title provided by Eversheds. Again, no point is taken on the authority of Eversheds for any purpose.
No.
Nor, as I say, was any such point taken in any oral submission to the trial judge. And the judge, in turn, unsurprisingly, proceeded to find that the mortgage documents were declarations of trust signed by agents of NIOC.
Yeah.
And we've seen the documents, the 2019 mortgage deed, and the judge deals with that at paragraph 186 and other paragraphs of his judgment below. And in relation to the certificate of title, he holds that also to be a declaration of trust at paragraph 191 of his judgment below, and we've looked at those passages. And those findings couldn't have been made unless the judge regarded the signatories as acting within the scope of their authority on behalf of NIOC. Otherwise, there wouldn't have been any form of declaration at all. And we do say that where no challenge was articulated as to the authority of these agents at trial, the judge was plainly entitled to assume that this was not a controversial issue. And as I say, there was nothing said in CGC's skeleton or in any oral submission whatsoever, including in Mr. Smuhar's oral closing, signalling that this was a contentious issue. Mr. Smuhar is a very fine advocate. If he was intending to take this point, he would have made it clearly on any view.
I'd be surprised if he'd missed it.
Indeed. It simply wasn't an issue. Now, if we take as an example, one of the documents, one of the two documents the judge found to be an express declaration of trust, the mortgage deed, that was witnessed, as we saw yesterday, that was witnessed by Mr. Byatt. He was called by the fund to give evidence at trial. He was cross-examined at some length by Mr. Smuhar, and was not asked a single question about the authority of the individual signing the mortgage deed or his authority to witness it. Not asked about the mortgage deed at all, in fact. And when a document states on its face that the signatories are authorised to sign it, when a solicitor signs a formal document on behalf of a client, the court is entitled to assume that such documents are authorised to be signed in the absence of any positive challenge as to authorisation. And with respect, the trial process would become unmanageable if the authority to complete or send every document, every letter, every email had to be formally proven.
Well, I think that's, there's some authority on this, isn't there? That if a document is signed ostensibly signed by an agent, unless the other side put in issue whether the agent is authorised,
yes,
you don't have to adduce proof that the agent is authorised. There's
see
a presumption that the agent was authorised.
if we can find the authority in question, but
I just got it rattling around in my mind that there is some authority.
it accords with my recollection. Yes, otherwise one would be proving every document in the trial.
Precisely. It maybe it's in that context actually, Mr. Benke. It may be in the context of documents that procedural rule in relation to documents that they're assumed to be authentic unless they're put in issue. It may be the part of the same.
I'll give that some further thought, see if we can provide any further clarity on that.
Yeah.
And we do say that it's completely wrong for CGC to say that the judge's that the judge's finding that NIOC's agents had authority to declare a trust would have been perverse, which is the point they make in paragraph 12 of their supplementary skeleton. And we do say he was entitled to assume authority. And we say that criticism of the judge is unfair and without foundation. My Lord, I'm not going to dwell on the procedural objections to taking the authority point for the first time on appeal. We deal with the Rhine shipping case in our supplemental skeleton at paragraph 16 to 19, but the court will be familiar with the principles. I'm not going to spend time on that.
No.
And then turning to some of the points made about the substance of the authority issue raised by my learned friends.
Yeah.
We do say that had the authority issue been raised squarely at trial, a number of matters would have had to have been explored. And I'll just give some examples of that, if I may.
Yeah.
Taking the mortgage deed first, the relevant findings of fact in the judgment we looked at yesterday are at paragraphs 186 to 188. As we saw in relation to ground 2, the mortgage deed was signed by Mr. Ragazar, who was appointed for that purpose by NTT as NIOC's attorney to sign the deed in the name of NIOC, which he did in the presence of the witness, Mr. Bayard. Now, one of the points taken in their skeleton by CGC is that the terms of the power of attorney granted to NIOC's attorney didn't empower NTT to declare a trust in land over NIOC's property, and they say in fact it expressly excluded any power to execute any document involving a transfer of ownership. That's in the appeal skeleton of paragraph 110. Just looking at the power of attorney, it's in the supplemental bundle at paragraph 30, that's tab 34. And you'll see it's dated the 25th of July 2018.
Yeah.
And I'm going to come back to a sequence of correspondence just before this power of attorney. But you'll see in subparagraph A, the power of attorney granted to NTT is in very broad terms at subparagraph A and B. And then the passage which CGC relies on is D, that does not cover sell or transfer of ownership of NIOC House. Just while we're on this document, the court will note the agreement to ratify and confirm at the bottom of the page whatever the attorney shall do in the exercise of the power hereby granted. Now, my lords, my lady, this was a disclosed document that was in the trial bundles for the trial below, but it was not referred to at trial. And accordingly, CGC made no submissions whatsoever as to the construction of this document to the judge.
D wouldn't apply anyway, because the whole, this is all predicated upon the mortgagee being written evidence of a prior trust that had come into existence.
Yes.
So the beneficial ownership has transferred on this hypothesis, albeit that it's not an enforceable trust.
I better leave my learner friend Mr. Mumford to deal with this point, which he's going to deal with.
Okay,
but,
well, I mean,
but,
that seems to me that's the right analysis. So that this restriction wouldn't mean that the mortgage deed wasn't a valid document. Apart from anything else, it falls within A.
Precisely, and
Authorised documents.
the party, the relevant background includes the fact that the parties had, albeit mistakenly, been operating on the assumption that there was a trust in relation to the property for many years. Again, it's something Mr. Mumford will deal with in some more detail. But as I say, this was not referred to at trial at all. And we do say that CGC's submission on the apparent restriction in D overlooks a number of important matters which might have informed the evaluation of the document at trial. As I say, when NIOC granted the power of attorney, it believed that it held NIOC House on trust for the fund, as recorded, for example, by the judge at paragraph 89 in his judgment below. And what's also significant is that the power of attorney was created and used in the context of a financing transaction with Bank Melli for the purposes of redeveloping NIOC House. And that transaction was to be entered into on the basis that the fund was the true owner of NIOC House. And if we look at a sequence of emails, it's tab 33 of the same bundle, and we begin on the second page of this. You'll see an email here from Mr. Cathcart. You'll see that he is dealing, this is to NTT on the 18th of June, so the month before the POA is entered into, refers to the possibility of transferring the property to NIOC pension fund. You'll see 5 lines down, NIOC would prefer its name to be taken off the title documents. Apparently the bank has also expressed the same view and would prefer, so Bank Melli would prefer to be dealing with the underlying reality, which is the pension fund rather than NIOC, i.e. ownership. The bank clearly finds the relationship between the two difficult to interpret and would rather have a clean situation going forward. But then you'll see in the next paragraph, Mr. Cathcart says it's his firm view that NIOC should retain its position as custodian trustee. He says then in the final paragraph, I don't believe, how do we deal with the bank's requirement that should be agreed for finance and security over should terms be agreed for finance and security of the property? I don't believe this will be a problem. Happy to work with the solicitors acting for the bank to clarify the issues of ownership and also look at the sort of documentation which will be required by the bank solicitors to properly effect a legal charge over the property. And he says that this will require assistance from NIOC, and he's sure that they'll be willing to assist. And at the bottom of the page says you should not therefore let the ownership issue interfere with your funding requirements. You'd equally not be concerned that ownership issues will prevent you from raising finance for the building. And then if we go to the previous page, see this is forwarded internally within NTT in the middle of the page. Mr. Cosgrove and Mr. Byatt, both of NTT, and you'll see Mr. Byatt refers to Peter Cathcart's advice. It's quite clear that we should leave the ownership of the building documents unchanged. And then a request to discuss with Dr. Zenedin. And then at the top of the page, Dr. Zenedin replies, saying it's now clear that as far as the pension fund is concerned, the legal opinion of the English lawyer negates the transfer of title from NIOC to pension fund. And agree with Mr. Byatt that we should proceed urgently to get the facility with the kinds of documentation that Mr. Cathcart will prepare to that effect. As to NIOC, they're only ready to issue a letter purporting to confirm the fund's title and their consent authorisation to proceed with the transfer, and then willing to draft such a letter for NIOC to sign. Mr. Cathcart prepares it, and then you'll see in the final paragraph that Dr. Zenedin also refers to needing a legal opinion regarding the possible effects of any sanction, court order against NIOC in respect to the property, should that become relevant. And then if there is such a danger, then we should immediately proceed for the transfer irrespective of its costs. So one can see, well, just to be clear, the point that Mr. Mumford will come on to, we do say that the mortgage deed is the declaration of trust for relevant purposes, and we say that there was authority to make the declaration, not just to evidence it. If that was what was required by Bank Melli, and that seems apparent from the exchange of emails. So we can see that Mr. Cathcart's view is against changing legal title. He goes on to say that he'll be able to work with the bank's lawyers to clarify the issues of ownership and to obtain the necessary signatures from NIOC. And
I mean, from the point of view of Bank Melli, the mortgage deed was entered into by both the fund and NIOC as mortgagors.
yes,
With the bank, so actually the point was cleared off. The ownership issue was cleared off anyway,
yes,
because one or other of them was going to be either legal, beneficial, or whatever.
yes. So Bank
No suggesting anybody else owned them.
No. For Bank Melli's purposes, that almost certainly would have been sufficient. And looking ahead to the mortgage deed, NIOC, we can see, authorises an attorney to sign it on the basis that the fund is the beneficial owner of NIOC House. And one can see from this email exchange we've just looked at, from the month before the POA was entered into, that both Dr. Zenedin and Mr. Byatt of NTT are involved in this exchange. And although Mr. Byatt gave evidence at trial, he was not asked any questions at all about this email exchange. You can also see Dr. Zenedin was involved, expressing a willingness to transfer legal title if necessary, and evidently there was a concern around sanctions. Now, his cross-examination on this email exchange was brief on day one of the trial, and was essentially focused on putting to him that his real motive was not the risk of sanctions. And as I have already said, neither Dr. Zenadin nor Mr. Byatt were asked any questions about the power of attorney. Not one question. And the court has my submissions that the power of attorney itself confirmed extremely wide powers upon the attorney, and you've seen the document. We say third, that's the second point. The third point is if the matter had been aired at trial, we would have submitted that the proviso relied on by CGC is not apt to prohibit a declaration of trust over NIOC House. The background documentation we've just looked at shows a willingness to do whatever Bank Melli wanted to clarify, wanted in order to clarify the legal status of the building in circumstances where the building was already thought to belong beneficially to the fund. And we do submit that it's trite law that a self-declaration of trust does not involve the transfer of any right, legal or equitable, from the settlor to the beneficiary. And the better view is that the creation of a trust, on the creation of a trust, the beneficiary acquires rights which did not exist before, but which rights are engrafted onto the right held by the settlor or the trustee. But analytically, that doesn't involve any transfer of ownership. And just by way of example, the point is well made in the New South Wales Supreme Court. Its authorities, tab 103, judgment of Justice McClelland, and Mr. Grant may complain it's not a high enough authority to show you, but it is approved in later High Court of Australia and indeed English Supreme Court authority. And if we go in this tab, it's tab 103, and PDF is 2154, and internal numbering and external numbering, bundle numbering. Page 11.
Page 11. So which page are we going to?
Very sorry, it's page. Could my lord just bear with me for just a moment? I'm sorry, it is page 11.
Page, the graphic point is page 3.
Page 3. It's page 311 of the report. I apologise, my confusion. It's letter E. And Justice McClelland in at E says the imprecision of the notion that absolute ownership of property can properly be divided up into a legal estate and an equitable estate. An absolute owner holds only the legal title with all the rights and incidents that attach to that estate. Where a legal owner holds property on trust for another, he has at law all the rights of an absolute owner, but the beneficiary has the right to compel him to hold and use those rights, which the law gives him, in accordance with the obligations which equity is imposed on him by virtue of the existence of the trust. Although this right of the beneficiary constitutes an equitable estate in the property, it is engrafted onto, not carved out of, the legal estate. And my lords, this, and my lady, this point was adverted to in the English courts by Lord Mance in Akers and Samba at authorities 23, tab 23, PDF 149. And if we go, please, to page 29 in this document, pick it up at paragraph 50, right at the bottom of the page, where Lord Mance says the metaphor of a division or split of title needs to be approached with some caution. Burroughs' English private law speaks of the falsity of statements which talk in terms of a division or separation of rights when rights are held on trust, or even worse, of legal and equitable titles existing before the creation of the trust. Burroughs, citing Australian authority, suggests an analysis according to which an equitable interest is not carved out of a legal estate, but impressed or engrafted onto it, which is obviously a reference to the authority we've just looked at. And then if we go to paragraph 51, it's unnecessary on this appeal to examine these slightly differing analyses further. What is clear on any analysis is that where a trust exists, the legal and beneficial interests are distinct. What affects the former does not necessarily affect the latter. Where an asset is held on trust, the legal title remains capable of transfer to a third party, although this undoubted disposition may be in breach of trust. But the trust rights, including the right to have the legal title held and applied in accordance with the terms of the trust, remain. They are not disposed of. And finally, on this point, tab 34.
Well, it's the point really he makes right at the end of that paragraph about the fact that a purchase by a bona fide purchaser without notice would override the equitable interest. And you can see, as a matter of analysis, if it were the case that there was a division of ownership, then you couldn't
do that.
You couldn't transfer the whole title to
Yes.
a bona fide purchaser without notice.
Separate questions about a breach of trust and so on in
Yeah,
those
sure.
circumstances, but
In the example given, the trustee may very well be in breach of trust, but if it's a sale to a bona fide purchaser without notice, he takes free of the equitable interest.
precisely. And so finally, on this point, if we go to the High Court of Australia, which is at Authorities tab 34.
Yes.
This is the Rajoda case, and very briefly, if we go to page 21. Sorry, my Lord, Lord Justice Zacaroli, that was PDF 468. Paragraph 44 at page 21. This is a judgment, as you can see, of Justices Bell, Keane, Nettle and Edelman. And just between letters B and C, it's very short. It's fundamental that the creation of a trust involves the creation of new equitable obligations, of new equitable obligations which are annexed to the trust property or engrafted or impressed upon it. Creation of a trust never involves movement of a property in the sense of conveyance of title from one person to another. And so if at trial CGC had wanted to argue that the reference to not cover sale or transfer of ownership of the house constitute a prohibition on a declaration of trust, it would have been necessary for them to persuade the court that those words bear some meaning other than their literal meaning, whether by reference to the admissible background material or otherwise. And in our submission, such an argument would have faced an uphill struggle. Finally, even if the declaration of trust in the 2019 mortgage deed was made without authority, it was plainly arguable that it was ratified by NIOC, transferring NIOC House to the fund in August 2022 on the basis that it was the true owner by directing Evershares to sign the certificate of title and again by its defence. We say all of these points should have been explored at trial. Certificate of title, I don't have much to add on this. We looked at it yesterday. But again, we say the judge is entitled to assume that Eversheds were authorised to sign the certificate of title without any positive challenge to it. And if implausibly Eversheds gave the certificate of title without authority, in that implausible scenario, we would have made the same ratification point at trial. Whether by the transfer of NIOC House itself, thus executing the trust, or by its defence in these proceedings. I'm not going to say any more about the defence. We deal with that in our skeleton, paragraph 33, in our main skeleton, core bundle, tab 6, page 53, but I'm not going to spend time on it now. My lords, my lady, before I hand over to Mr. Mumford, there were just a few points to go back on from yesterday, if I may briefly. First of all, I had meant to do this and I forgot, but I apologise. I am grateful to Professor Swadling of Oxford University for drawing my attention to the US materials I referred to yesterday. I wouldn't want to claim responsibility. I mean, take credit for deep analysis of the US position. I was unaware of the history of the statute of frauds in the USA before Professor Swadling very kindly drew it to my attention. He's been following this case closely. Overnight, my lords, my lady, we looked at the transcript and I saw to my horror that at page 115, lines 8 to 19, I misspoke. My Lord Justice Zacaroli asked me what the position would be if a trustee under an oral declaration of trust dealt with property in breach of that trust. And I said that it might be a fraud on creditors. And I apologise, that was a mistake on my part. I'd meant to say fraud on the beneficiary, but even that might be an overstatement because it wouldn't necessarily be in every case that every case of breach of trust involved a fraud on the part of the trustee. And I didn't mean to suggest that creditors would have any remedy in such a situation. That'd be contrary to the argument I made under ground 3 yesterday. And just to summarise, the way we see the position is this. First, the starting point is that an oral trust would be unenforceable. As a consequence, the beneficiary could not sue for relief for breaches of trust by the trustee. However, that would not mean that a breach of trust had not occurred. The position would be analogous, say, to a time-barred cause of action. There would be an infringed right, but no available remedy. But as the point I was making yesterday was if the trust was then executed by reference to the US position, if the trust was executed, the creditors would have no standing to complain about that. And I make this further point that if the trustee or his agent ever happened to sign a document, or the beneficiary was able to obtain previously unavailable or lost writing evidencing the trust, the trustee would be answerable for any breaches of trust which he had committed since the origin of the trust. As we saw from Gardner and Rowe, that dates back to the original oral declaration. So even a breach of an oral trust comes with potential risks for the trustee. And we touched on this yesterday. This may all sound harsh in respect of beneficiaries, but the reality is that the harshness of the position might be ameliorated by other aspects depending on the facts. For example, a common intention constructive trust might arise in certain situations, particularly if there was detrimental reliance, or in other cases by the doctrine in Rochefoucauld and Bousted, might be restricted on the authorities to trust created by conveyance, which we discussed yesterday. But there's quite a heated academic debate on the precise effect and how far Rochefoucauld goes and whether it's that narrowly confined or not. And I do invite.
Just one question on that. If it isn't confined to a situation where you convey to someone else on lawful declaration, it would seem to cut across what everyone says that Section 53(1)(b) does.
I mean, it's worth reading.
In the sense that if it, because the result in that case was that the beneficiary could actually enforce the trust against the third party to whom the property could be conveyed, even though there was not the right sort of evidence.
And the argument has been run that that would drive a coach and horses through the statutory provisions, and this is part of the academic debate which has raged. And I do invite the court, I didn't have time to take it in detail, Professor Swadling's article on the effect of Rochefoucauld, I gave the reference yesterday, is worth reading, and he sets out the academic controversies. I think it's fair to say that as things stand, it's probably confined to the situation we discussed yesterday, where trusts arise upon conveyance of property.
That's helpful, thank you.
I think I dealt with some of the other points which arose already. The only other point I should mention is that in answer to the question from my lady, Lady Justice Falk, you asked me about the conveyance, the definition of conveyance in section 74 of the Law of Property Act.
Yes.
It's not in the bundle, and we'll make sure it's put in there, but conveyance is defined very widely in the LPA. It's section 205, and conveyance includes mortgage, charge, lease, assent, vesting declaration, vesting instrument, disclaimer, release, and every other assurance of property or of an interest therein by any instrument except a will. So it's defined very, very widely for the purposes of the LPA, and we'll make sure that's put in the bundle. My Lord, unless there are any questions for me, I was going to hand over to my learned friend, Mr. Mumford.
Thank you very much.
Lords, my idea, I wonder if we could have a moment just to. Should only take 1 minute. I'm most grateful. My Lords, my Lady, I was, as Mr. Banky indicated, going to address you on the question of declaration of trust, which is the other aspect of the respondent's notice point 2, and this, my Lords, my Lady, involves a challenge to the findings that the judge made, that there had been 2 relevant declarations of trust, one in the mortgage deed and the other in the certificate of title signed by Eversheds. And it is important to underscore that for the purposes of this part of the argument, we're considering these documents as the relevant declarations, not merely as evidence of some antecedent declaration. Albeit it is, of course, right and indeed important in the approach that one takes to this issue and all issues, that there was at trial and was found at trial to be a consistent understanding on the part of the NIOC and the fund that the property was already owned by the fund in the beneficial sense. Now, we say essentially 2 things on this aspect of the cross appeal. Firstly, that this is an impermissible challenge to what are essentially findings of fact made by the judge, and no sufficient basis to go behind those findings is identified in my learned friend's arguments. Secondly, we say that insofar as my learned friends seek to raise an issue of principle here, there is no issue of principle. On their face and read in their relevant context, these documents clearly manifest an intention that the property be held on trust for an identified beneficiary, i.e. the fund. And we say there's no more required in law for there to be a valid declaration of trust such that the judge's findings are unimpeachable legally as well. I wonder if I might start by looking at the challenges that are made to the judge's findings, and they are at Core Bundle tab 8, page 91 in the addendum to the respondent's notice. And there's a series of sub-paragraphs here, and if I can take the court through them, they broadly fall into 4 or possibly 5 categories. The first sub-paragraph makes the point that NIOC was under the mistaken belief that retirement fund already...
Page 91.
Page 91, yes.
Oh, yes. Oh, weird. Sorry.
Does my lord have it?
No.
It's an appendix to the respondent's notice, which should be at tab 8 of the core bundle.
Well, curiously, I have got... I'll do it from the screen, it's fine. But for some reason I've got... Oh, I see what's happened. Okay. Yeah,
Grateful. The first point is the point about NIOC being under a mistaken belief that the retirement fund already owned NIOC House. My lord, we say that actually that point recurs. If one skips forward to the third point, one sees, and I won't read it all out, but one sees that essentially that concludes with the same point, that NIOC had already been advised that it was holding under a custodian trusteeship. Likewise, the fourth point, which is that they weren't aware of a reason to make a declaration of trust because they weren't aware of the lack of separate legal personality. And similarly, over the page, the sixth point, the punchline to which is that a reasonable person would have understood that the mortgage document simply repeated a state of affairs already believed to exist. So there's a package of points which all seem to turn on the proposition that one can't declare a trust when one already believes one exists. And I'll come on to that because that's really the main point in issue on this part of the appeal. The second point, going back over the page, is that it was factually inconsistent, one sees this in the final line, with an intention to declare a trust that there was a belief that the property was held on an Iranian law amanat. I'll deal with that point separately in a moment. And then the third class of point we get is on paragraph 5, which is a point about the inherent probability, or improbability as they would have it, of there being a declaration of trust through the mortgage documents. Said not an obvious or natural vehicle to make a declaration of trust. And then point 7, we have the point on authority, which my learned friend Mr. Thankey's already addressed. And then finally at 8, we have a point about the fact that subsequent to the mortgage deed was not relied on by Eversheds as being the trust deed when the land registry issued a requisition and sought confirmation as to what the relevant trust document was. Now, just pausing for a moment on the authority point, I said that Mr. Thankey had dealt with that, and he has, and I respectfully adopt and don't repeat anything he said. But I would say this in addition, that on the question we're here considering, which is what is the meaning and effect of the mortgage documents, we would say that the question of authority is irrelevant. Because it's common ground that the question is an objective one. What intent is objectively manifested? what privately may have been the position as between the fund and, or rather NIOC and NTT as to the actual authority of NTT, we would say is a purely internal matter, not relevant to how the reasonable observer would understand the acts and declarations made. I'd also make this point, in our submission, it's putting the question back to front. The relevant question is, first, did NTT have authority to execute these documents? Answer plainly yes. Indeed, as we saw in the skeleton argument at trial, that was actually conceded. It's described as a document of NTT, of NIOC. But the first question is to ask, was there authority to execute it? Then there's a question as to what the legal effect of that document was. And that's the right way round to approach the question in my submission. Now, as I said, there's an overarching point, which is, in our submission, all of these points are really seeking to impugn the judge's evaluation of the factual case and the evidence before him. We say that, therefore, CGC needs to surmount the high hurdle set out in cases such as Falk and Volpe. They need to satisfy your lordships and my lady that this is a view that no reasonable judge could have reached. And if authority is needed for the proposition that questions of whether or not a declaration of trust has been made or whether there is the requisite intent to create a trust are questions of fact, then we would point to Paul and Constance. I won't turn it up, we might look at it shortly. But in Paul and Constance, the Court of Appeals said that the relevant question on this sort of issue is whether there is sufficient evidence to justify the judge's conclusion. Now, if I can just go through the groups of points as I've identified them, as I say,
If you think about it, it must be a question of fact, mustn't it?
Yes.
If you're looking at the status of a particular document, as to whether objectively it could gets to the stage of demonstrating what needs to be demonstrated, and therefore it must be a question of fact, not a question of law.
Yes, I mean obviously it's a question of fact informed by a question of law.
Of course.
But that doesn't make it any less a question of fact.
It's a question of fact.
Yes. So, my lord, I'll come last to what we see as the main point, the one that one sees recurring through a number of these points. If I can just pick off first of all item 2, which is the point about the Ammanat. Now, this was, if we could turn up the judgment, and it's the suggestion made that understanding the relationship in terms of an Iranian law Ammanat is factually inconsistent with believing there to be a trust. This is a point that the judge expressly took into account. If we could turn to the judgment at Core Bundle tab 15, and it's page 194. And if you haven't already, could I invite you just to consider paragraphs 160, 161 and 162. Well, just to explain the reason, you may have picked this up from the skeleton arguments, but the reason why that the Ammanat is said to be significant and inconsistent with the trust is because Iranian law doesn't recognize a property interest being held in the custodian. But that's important. It, of course, does recognize a property interest being held by what we would call the beneficiary. In this case, the fund. But the point I emphasize here is that the judge had the submission firmly in mind. He accepted that he ought to have regard to this point. but he said that the weight to be given to it would depend upon the clarity of the language, among other things. And we say that that's an unimpeachable self-direction, and there's no reason to go behind that the weight that he chose to accord to the existence of or the believed existence of the Amanat relationship when he eventually made his findings on this. In any event, my lords, my lady, the point goes nowhere, because there isn't any relevant inconsistency under both the Iranian law analysis and the English law analysis. The fund is the true owner, in inverted commas. It has the beneficial title, it has the right to the fruits of the property and the enjoyment of the property. The reason, as I said earlier, that an amanat differs from a trust is only that there's no conception under Iranian law of the custodian, that is NIOC, having a form of property interest, of legal title. But obviously everyone knew that NIOC was the registered owner of this property. So that's a point of no distinction, or rather a distinction that makes no difference. We'd also say this, that it forms no relevant part of the legal inquiry, we would say, and in this respect maybe we're going further than the learned judge did, but what the parties may subjectively have understood the correct legal analysis to be of their relationship is neither here nor there. As we get from cases such as Paul and Constance, one doesn't need to understand the law to declare a trust. One doesn't need to have any particular conception of what legally one is doing. And for what it's worth, just finally on this point, there's ample evidence of NIOC actually understanding that there was a pre-existing English law trust. And you've seen the judge's findings that I believe Mr. Grant took you to yesterday, where he found that there were a number of documents that would have amounted to declarations of English law trusts in the pre-2019 period, but for the fact that the fund didn't have personality. So, my lord, that's the point on the amanat. The next is this point about the inherent improbability of there being a declaration of trust in the mortgage documents. Again, a point that the judge had in mind, if one turns forward to paragraph 189 of the judgment, where the findings are made. Perhaps I could invite my lady and my lords to read that paragraph again. I'm sure you've looked at it before. So obviously the suggestion that in the context it was implausible that a trust would be intended is a submission that the judge had firmly in mind, and he rejected it because in his assessment of the evidence and the documents were sufficiently clear to outweigh that consideration. But we would say that insofar as it's permissible to get into the substance of the point at all, that the judge was obviously right that there was nothing inherently implausible about these mortgage documents containing declarations of trust.
Yes, but the point about implausibility is another example, isn't it, of impermissibly introducing concepts of subjective intention into what is an entirely objective test.
Yes.
It's
Absolutely.
You might just as well saying the money is as much mine as yours or yours as mine is implausible to be a declaration of trust, but as a matter of objective intention, it was a declaration of trust.
Exactly. My lord makes the point I was about to make myself. So I'm great.
You don't need to use the word trust, as the judge also accepts.
No, you don't. But I do make this point too. I mean, if one looks at the contextual material, and this isn't an exercise this tribunal should be doing, but if one does, for example, the string of emails that Mr. Thankey took you to a short while ago, one sees that the bank was concerned about the ownership interests, about the relationship between the parties. And NIOC was saying we're willing to give appropriate confirmation as to the ownership position. So it's a perfectly plausible context in which to declare a trust in our submission. There was then the point about Eversheds not relying on the mortgage document as being the declarative document, but rather relying on a historic position. Again, that's met by my lord's point that what Eversheds subjectively understood about the position is neither here nor there. So can I then come to the what seems to be the main thread that runs through the other objections, and that seems to be that if you mistakenly believe that a trust already exists, then necessarily that's inconsistent with having an intent to declare a trust. We say that's insofar as that is said to be a proposition of law, it's obviously wrong. Now, obviously, the judge had firmly in mind that there was an antecedent belief that the property was already held on trust. So it's a point the judge would already have taken into account and been aware of. He was absolutely right to regard it as not undermining in any way the objective manifestation of an intent that there be a trust, which he found in the two mortgage documents. We say the error that underlies the approach that CGC seek to take is really twofold. First, again, they're aligning the subjective intentions of the putative declarant with the objective manifestation of its intentions. Yet it's clear the analysis is subjective. But secondly, insofar as what they're saying is you have to objectively manifest an intent to change a relationship, we would say that that is importing an additional requirement for which there is no support in the authorities whatsoever. If one thinks about it, it can't be right that one has to manifest an intent to change a state of affairs, or that having an erroneous belief that a trust already exists precludes a valid declaration taking place. What is the difference in terms of the intent that one manifests to be subject to the obligations of trustee between saying, I declare myself from now to be trustee, and I declare myself already to be trustee? It can't possibly be right that there's some difference in the legal effect of those two statements. And why should it matter that if in making the second statement...
If you think about it, in a case like Gardner and Rowe, for example, the subsequent written manifestation or proof, or whatever, however it's described. I mean, on one view, you could say, well, that's in a sense, the writing is itself a declaration of some kind, albeit a declaration that there's already a trust. It's been a trust for the last however long it was. And absolutely, the idea that because you think you've already got a trust, when you produce something written which objectively satisfies it being a declaration, the fact that you might subjectively have thought you already had one can't make a blind bit of difference, can it?
Very much our point, my lord, very much our point. Indeed, it's worth emphasising that in Gardner and Rowe, it is that the later document is called a declaration of trust by the court.
But it wasn't interpreted as that, was it? It was interpreted as the writing sufficient to prove
a prior declaration orally.
Yeah. But this may come down to what's meant by a present intention to create a trust relationship, and whether that is there in order to ensure that you're not, the intention isn't to create one in the future, or whether it also covers the case where you're not saying, I created one in the past.
It must be the former. we would submit. And indeed, if one looks at, I'm going to come to this in a moment, but if one looks, the only support for the case they seek to advance on this is an article by Sinead Agnew, which they characterise as importing this element of the test. And in fact, it's quite clear that what the authors of that article are concerned with is eliminating future intent. And we can look at the cases that make that clear.
Just to follow up on that, if I declare a trust on day one, which is a valid declaration of trust, and then a week later I do it again, is the second declaration of trust?
Well, there's no reason why it shouldn't be if it turned out you were wrong about the first one.
But what if I'm right about the first one?
Well, then it doesn't matter.
Yeah. Well, it might.
But if the first one was an oral declaration which is otherwise unenforceable, that's the point, isn't it?
Well, then the second one is treated as writing of the first, perhaps, or well, is it, or is it treated as?
Well, we would say that it's well, if the first one is wholly of no effect, and let's assume we're not in a Section 53 situation, it's of no effect because it's a declaration over future property.
Yeah, I'm considering one which is, so take the point where it's simply oral, therefore it's a 53(1)(b) situation.
Okay.
And the second piece of writing is itself purporting to be a declaration of trust. Is there any reason why that, well, is that a declaration of trust if in fact there has already been a trust created?
It certainly could be, yes. It
But
would depend.
surely you'd be saying consistently with your earlier arguments that it isn't. It may evidence it because it evidences the earlier.
Yes, we wouldn't. I mean, it depends why one's asking the question, but
it's relevant to the dates, isn't it? Because
yes, if one had declared a trust orally at the earlier date and the only difficulty was the absence of writing, then our position would be that that is when the trust was created.
yes.
That's the whole argument on ground 3 and Respondents Notice 1. But insofar as it turns out one's wrong about the effect of the first trust, not because of a problem with evidence, but because there's some more fundamental problem, such as in this case, where there was no certainty of object because the fund hadn't yet been incorporated, then in that example, your second declaration would be the declaration, and there's no reason why it couldn't be.
So just going back, sorry to swap around, but to the objective, I suppose a subjective point. The objective observer of this situation knows that there was that the party so-called declaring the trust thought they had already done so and didn't realise that was inadequate because there was no certainty of beneficiary. They didn't know that. So might it not be said that the objective observer, not just the subjective intention, the objective observer would not think that they were intending to declare a trust on the second occasion because they thought they had already declared one?
But that assumes that there has to be objectively some requirement in it that you are creating a relationship de novo. But why should there be? Why should you be any less bound by outwardly manifesting clearly and unequivocally an intent that you are bound by a trust if you happen also to erroneously believe that you already are?
But isn't part of what has to be brought into account in assessing whether there's an objective intention is that the fund didn't have a legal personality until the 25th of September 2019. So that we said they thought they created a trust previously. The fund in fact didn't have a legal personality. When the fund has a legal personality, they then redeclare, if you like.
Yes.
In order to cover the fact that the fund previously didn't have a legal personality.
Yes.
Because, as the judge found, the earlier declarations were of no effect.
Yes, but I mean that might be one interpretation of the facts, but it wouldn't. We would say it wouldn't matter even if it wasn't done consciously because of the incorporation of the fund.
Indeed,
Say,
on the judge's findings, they didn't appreciate that there was a separate legal personality when the mortgage documents were executed.
as I understand the judge's findings, he does. I don't think he makes an explicit finding as to when NIOC became aware of the legal personality.
Well,
but he's certainly he
NIOC
finds.
was maintaining at trial that the legal personality was created
A-
earlier, so it's
absolutely.
not really
No,
consistent
absolutely,
with that,
but
so-
obviously it did execute fresh articles which had the effect of conferring legal personality, or rather the fund did, on that day. So we don't know when their understanding changed, I think, on the judge's findings. I mean, I'll check that in the short adjournment, but I don't
Should
think we
we,
do.
should we have a 5-minute break now then? So is that a convenient moment?
Yes.
Okay.
All rise.
There might well be a difference in the second declaration and the first, in which case you're bound by the second declaration. If you see, he talks about throughout about in the early days the accounts and the fund and the legal personality. So it's not very clear from I think his view is that they always think
Sorry,
he
yes.
makes a finding.
Exactly.
No.
When they're making 2014 declarations of trust, it's certainly clear that they didn't realise they didn't have
I think paragraph 175 is the closest one gets.
Sorry. Well, just on the point that Falk was making.
Oh yeah, okay.
by Sir Fable.
Mr. Martin, before you continue, is it possible we're fixating too much on a particular moment in time? Is it right that a trust can be declared by conduct over a period of time?
It can.
Right. So it may be the case, it doesn't particularly matter which particular date. It may matter for some purposes.
Well, that's very much the effect of Paul and Constance in cases like that. Indeed, Lord Justice Scarman makes the point in Paul and Constance, which I'm going to go to in just a moment, that it wasn't actually possible to pinpoint the precise date on which the declaration was made. There were just repeated statements which were declarative in the relevant sense.
Yeah.
As to the question raised just before we rose, it's not clear from the judge's judgment what findings he made. Indeed, he doesn't appear to have made any findings about what subjectively was understood about the significance of the articles in 2019. Obviously, the position that NIOC had taken was that there was separate legal personality before that date, and it had maintained that position throughout. So I don't know that I can take the point any further than that. But as I say, one's subjective motives for declaring are not a matter that's relevant. But even if it were right that one were labouring under a mistake and so believed that the subsequent declaration was otiose, that wouldn't prevent it from being a declaration. In terms of the law, I was going to turn first to just a statement of the general principle in Lewin that Authorities Bundle 163, page 9, which is on the requisite intention to create a trust, and under the heading General Principle at 5002, it says wherever a person having a power of disposition over property manifests any intention that it be held upon trust for another, and then the court, whether subject to formalities, will give effect to that. So that puts the test in sort of time agnostic terms, and in a manifestation of intent that property be held on trust.
Yeah.
And if one then turns to the cases, I've mentioned Paul and Constance repeatedly. Let's turn it up at Authorities 94.
Yeah.
I'm sure my lords and my lady are very familiar with the facts of the case, and unless it's of assistance, I won't go through them. But
Yeah.
The nub of the point is that, as one sees from the findings that are made at page 531, at the bottom of page 531, the nub of the point is, as I said earlier, the repeated statements of what is understood to be a present state of fact. Sorry, page 5. Yes, page 531 of the report, page 5 of the bundle.
Yeah. Sorry, which passage are you referring to?
At the bottom of the page by letter H.
When one looks at the detail there?
Yes. Perhaps if the court could just read that, and then over the page, the next paragraph. And indeed, perhaps to the end of the redlining. So you see there are repeated statements. The money is as much yours as mine. And the significance we draw from this is two things. First of all, there are repeated statements, and it's not suggested that only the first in time can be the effective declaration. But secondly, they are statements as to what is already believed to be the state of affairs. There's no objective manifestation.
It's the two things, isn't it? It's the point that my lord just put to you, that you can have a course of conduct that amounts to.
You have a course of conduct, but you can also have a statement which manifests.
Also, if you make a subsequent statement that's confirmatory of an existing position, that can amount to a
That could
declaration
be
as
the
well.
declaration, if that for some reason there were a problem with, if you've misunderstood the previous position. And what well, one sees the point that I made earlier just after letter D, that it's not easy to pinpoint the specific moment of declaration. But then at the end of the paragraph after E, the use of the words on numerous occasions constituted express declaration of trust. And to similar effect, we've referred to in our skeleton, but I won't go to it in the interest of time, is a case called Rowe and Prance, which is at tab 109 of the authorities bundle. It's quite a similar case concerning, in that instance, a boat rather than a fund in an account. But again, there the settlor repeatedly talked of trust property in terms of being jointly owned. And there's no suggestion in the case that there was some moment at which it was announced that the relationship had switched to one of joint ownership or trust. There was nothing to suggest in that case that one had to either subjectively appreciate or indeed objectively manifest an intent to change what one believed to be the existing state of affairs in order validly to declare a trust. So we say that, CGC suggests that these two cases, Paul and Constance and Rowe and Prance, can be distinguished because there's no, in those cases, there wasn't an error that needed to be corrected. We say that doesn't matter. As I said, the important thing that emerges from the case is that one can validly declare a trust without subjectively having or even objectively manifesting an intent to change an existing state of affairs. The declaration can be found in a statement of what one already believes to be the case. And whether that belief is correct or not is irrelevant. It's because that one's subjective understanding of the legal effect of one's words ought to be left out of account. And we also rely in our written arguments on two cases where there was, it appears, some error as to the previous trust relationship or the pre-existing trust relationship. One is a case called Northcliffe, which is at tab 87. And one gets the, if I could just summarize the facts very loosely, which one gets from the head note and then from the statement at the bottom of page 651, internal page 1. Lord Northcliffe had executed a trust over some properties, which included future property. And because there was no consideration, the trust over future property was void. He then subsequently executes a will, which one sees over the page, page 2 of the bundle. It's about 2/3 of the way down the page. And by that will, he confirms the undermentioned deeds and settlements. Now, what has happened in the intervening period is that the future property has been acquired by him. So he's no longer got a problem with declaring trusts of future property. But he confirms the undermentioned deeds, in other words, the prior voluntary settlement and settlements. And I declare that the provisions hereby made, that's the will, are intended to be in addition to them. And it's held that that subsequent will, which confirms the previous settlements, which, as it happened, had been void, but confirms them once the property had been acquired,
Yeah.
were effective declarations of trust. And one sees that in the very short judgment at page 4 of the authority.
Yeah.
To similar effect, we say is Gray and IRC, which is at tab 54, which we looked at previously, or looked at in the House of Lords previously for different purposes. But just to remind my lady and my lords of the relevant facts for our purposes, what happens is that at the beginning of February of 1955, Mr. Hunter declares shares to various individuals to be held to his order, and then on the 18th he gives a direction orally to hold the shares on certain trusts. That's ineffective because it doesn't comply with section 53(1)(c). Then on 25th of March 1955, Mr. Hunter and the transferees execute declarations of trust, which record that they had been holding the shares since the 18th of February 1955. So again, one has a situation where there is a declaration that is confirmatory of what is understood to be an existing position, but in fact they were wrong about it because the pre-existing direction to the individuals to hold the shares was void. And at page 706, internal page 706 of the judgment, which my lords will find on page 17 of the bundle, I think it's might be 954 if for those using the electronic copy.
So we're in the Court of Appeal here.
We're in the Court of Appeal, yes. I'm sorry, I should have made that clear. We are, yes. So this isn't the point that this authority is usually relied upon, which is the question of section 53(1)(c). This is considering what the effect of the subsequent declaration was, because there was a concession made by counsel that the subsequent declaration would be the effective declaration and so potentially taxable if the first one were void. And the arguments about whether the first one's void, but what's important is the Court of Appeal tests that concession. And perhaps if the court could read the red-lined, effectively the page 706.
So 705 or 706?
Sorry, I think one can pick it up from 706, page 17.
It's really the passage at the top of page 707, isn't it?
Yes.
Where he's making the point, Lord Evershed there is making the point that to the extent that the declaration on the 18th of February was void or invalid, the subsequent statement on the 25th of March constituted a declaration of trust.
Yeah, he clearly had thought about the possibility that the second declaration might not work, and it might simply be that one's got no valid declaration at all. That he satisfies himself that the confirmatory declaration can be the effective declaration. And we say that's very much supportive of our take on the law. My learned friends seek to distinguish these two cases on the basis that there are further documents which describe themselves as declarations, but we say that's a point of no relevant distinction. The fact is that what one has is documents which are recording what is understood to be the existing position and confirming it, and that's held to amount to a declaration of trust, and so too with the mortgage documents in our case. Indeed, there's actually another example, or two other examples in the authorities that we hadn't identified in our skeleton, and perhaps I could just show you them briefly. The first is grant and grant, which is at tab 53 of the authorities bundle.
Yeah.
This is a case that I don't think we've actually looked at, but it's cited by my learned friends for the proposition, which one sees in the head note, that a declaration need not be in writing, but the words must be clear and unequivocal and irrevocable. But what this case concerned is a dispute as to the ownership of various chattels, and the issue is whether or not a trust of those chattels in favour of the widow had been effectively declared, and one can pick it up perhaps over the page 2 of the bundle.
Yeah.
Just before, about 5-6 lines up from the bottom of the first substantive paragraph. I think that is what is established in Ex parte Pi, on which I've no comment. I've had to comment very often. In many other cases, I'm of the opinion that it would be just the same if A were asked by C, have you given the stock standing in your name to B? And A said in reply, yes, I have given it to B, and it is his property. I'm also of the opinion that if, without being asked, he voluntarily said, I have given the 1,000 consols standing in my name, etc., etc., that would constitute a valid declaration of trust of the stock, though it still remained in the name of A. And perhaps you could read yourselves the next paragraph, which is to similar effect. Again, one sees, one could declare, I do now give it, but I'm also of the opinion that it's sufficient if one makes the declaration, I have already given it. Indeed, that's the language that was found to have been used in the case. So over the page on page 3, the final paragraph, for example, the exciting topic of a souffle dish. At the same time, he said that he'd given my sister a souffle dish, that she'd only used it once. In my opinion, that is also an express declaration of trust, for, as I before said, no technical words are necessary. And here he stated that he had divested himself of the whole property in them. And one can see other examples. I won't take up time with going through them, but clearly statements that are of effectively historic as to already having divested oneself can be binding. Finally, I was going to draw attention to Ong and Ping, which Mr. Thankey looked at yesterday. I won't go back to it, but for your note, it's at tab 91. And in that case, it bears note that what happened in that case is the solicitor had wrongly advised the putative declarant that she already was a trustee of the property before she executed the trust deed. And one sees that when one looks at paragraphs 51 to 54 of the Court of Appeal decision. So one had the execution of the trust deed that missed the name of the property, and one had the letters that supplied the necessary intent to be a valid declaration. But before that, the putative declarant was already thinking, because she'd been wrongly advised, that she was a trustee. And there's no suggestion in the Court of Appeal's judgment that that somehow makes the declaration ineffective.
So just remind me, because we looked at it in the context of evidence, 53(1)B evidence, and wasn't that the finding, or what did the court say the actual declaration of trust?
Effectively, you have maybe easier if we go to it, but if I can summarise, you have 3 steps. You have advice given that at the point she acquired the property, she was a trustee. You then have the execution of a deed that misses out the property. And you have some correspondence around that which is held not to be sufficient evidence, but I think it's held is sufficient to evidence the declaration. And then stage 3, one has a later letter repudiating the trust, and that's the evidence.
But that's relied on as the evidence, not the
Yes.
declaration. So you think if it's the letters around the declaration of trust that.
Yes, it seems that there's a finding of a declaration at stage 2, and then the evidence comes in the letter repudiating. But it's not suggested that there's any problem for the declaration, that she was already labouring under a misapprehension of an existing trust. Can I finally on this just turn to the one thing that my learned friends are able to point to, which is the article from Sinead Agnew and Simon Douglas that I mentioned earlier at Authorities Bundle 150, tab 150, page 3015. As I say, this is an academic article and about declarations of trust, and the relevant page is page 13. Which I think is 3027 in the electronic bundle. And perhaps you could just read the paragraph under declarations as intention to be bound. That one paragraph there. And if I understand my learned friend's case, they place reliance on B. They say it's not sufficient that you have an intention to hold rights. You've got to have an intention that by the very words or action, the trust relationship should be immediately constituted.
That point's presumably developed below, is it?
It is, and if one looks over the next 2 pages, one sees the cases that the authors cite for the proposition, it may be that it's easiest just for the court to read to themselves the page and a half, starting under the heading. So if one turns the page on Opus to page 14, thank you, under the heading "An intention that by the settlor's very words or action the trust relationship be constituted."
Okay.
If one looks at that page and the following page, one sees the cases that are relied on.
What's the point we get from those pages? That it's all about an intention to create trust in the future.
Exactly. All of those cases are cases where the problem was that the intention was to execute some further document or to create the trust in the future. So that is what Agnew and Douglas are driving at. I mean, obviously they're not suggesting, they couldn't be suggesting that one has to have some subjective appreciation that one is creating a trust by one's words. That can't be the law. And indeed isn't the law, as we've seen. Nor, we would suggest, are they saying that there's got to be some objective intention that the trust only comes into existence now. The point that's being got at is that it can't be an intention that a trust be constituted at some point in the future. And all of those 3 cases are cases that suffered from that defect. But none of those cases, nor the article itself, suggests that if one states in a document that one regards oneself as already bound, to hold a property for the benefit of another, that cannot be an effective declaration. And we might ask, well, why on earth should it not be? So, my lords, my ladies, for those reasons we say there's no error of law in the judge's approach to the mortgage documents being declarations, and absent any such error, there's no reason whatsoever for impeaching his decision that they were indeed declarations of trust. Just finally, there are 3 cases that are mentioned in my learned friend's skeleton on this point, in addition to Agnew. We've tackled them at paragraph, they're mentioned at paragraph 13. We've tackled them in our document. I wasn't proposing to say any more about them at this stage. They're nothing on point. But if my learned friend is going to go to those cases and rely on them, I might say something about them in reply. But the 3 cases are Ong and Ping, which, as I've already said, is actually a case in our favour. In re Cousins, which is again a case where there was a problem with a future intention to declare a trust not sufficing, or rather to declare a charge. And then there's the case in re Shebsman, which is often cited as authority for the proposition that one shouldn't be too astute to find a trust, but that we would say was a case about whether or not one could superimpose a trust on a contract, and nothing to do with our case, where one's explicitly got language of a trust.
Yeah.
So, my lords, unless I can assist with anything further, those are my submissions.
My lord, I have a few additional points. I'll be very brief. First of all, point of clarification on yesterday, the New South Wales Conveyancing Act of 1919. Your lordship expressed some surprise that it predated,
Yes.
and it doesn't, because
Yeah.
it was section 23C, that was one of a swathe of introductions brought in 1930. So 1930, New South Wales Conveyancing Amendment Act amended the 1990 Act and brought in, amongst other things, section 23C. So that's that point. On Respondents' Notice 1, all I wish to do is to invite the court to have a look at the fund's supplemental skeleton. It's core bundle, tab 26, page 362. So this is on Respondent Notice 1, the question of whether the effect of non-compliance is unenforceability or voidness. Paragraph 38 of our skeleton, it's on the screen, sets out 4 principles, and we've looked at most of them in the course of this hearing. Let's focus really in the 2nd, 3rd and 4th, the separability principle, retrospectivity principle and the unenforceability principle. Separability and retrospectivity principle most obviously borne out by Gardner and Rowe, but other cases are authority for the same proposition. My simple point is this: if Crescent is correct and the consequence of non-compliance is unenforceability, that would impugn all those principles there. You could not have the concept of a later declaration somehow reviving what was in the first place on their analysis a void or invalid trust. So that's all I wish to say in Response Notice 1. And I now turn to Response Notice 2.1, following from what my learned friend Mr. Mumford has just said. The key point in Crescent's argument is the proposition that a mistaken belief is a necessary or sufficient bar for the validity and effect of a trust. I say that if that were so, it would be undesirable and problematic. There's already been debate between the court and my learned friend Mr. Mumford on some factual scenarios, whether the example given by my Lord Justice Zacaroli and others. May I put one other scenario into the mix? A settlor or trustee purportedly executes a document and then receives legal advice that the efficacy of it is in doubt. There's obviously an example because of some doubt as to whether it's properly executed. Concerned by the lack of certainty, but unable to predict what a court would make of it, the party enters into a new document, a for avoidance of doubt document. My question is this: on the Crescent's case, would that document satisfy certainty of intention? It would be highly impractical if it didn't. And if Crescent say, well, that's different from our case, the question is, how does one draw the line? The reality is that there are plenty of cases where parties enter into deeds, documents on a belts and braces approach. In the pension sphere, capping deeds are frequent to put to bed this very doubt. As to what the word present means, we say, this is picking up the point my Lord Justice Zacaroli has made, simply requires a coincidence of the three certainties: intention, subject matter, and object. That's all it seeks to achieve. Finally, I wish to turn to an analogy we make in our supplemental skeleton, where we raise two related ameliorating principles of equity to highlight the artificial nature of Crescent's argument. The three cases, Davies and Richardson Wallington, the Jersey case of what I'm going to call Rushinovich, and finally Shannon and Vayavi. In the interest of time, I'll go directly to Shannon because it addresses the other two cases. So the reference for Shannon is AB 112. Those in the hard volume, it's volume 4, my Lord Justice Zacaroli, it should be 2299. And so, if I explain what this was, there'd been a corporate restructure and the validity of the 1999 deed was in issue. That sought to introduce increases or changes to increases to pension benefits. The validity of that deed really turned on whether management had replaced Vayavi following a corporate restructure. And the deputy judge held that the execution of the 99 deed met the requirements for substituting principal employer, thus it was effective. However, there was a fallback argument, which was the principle in Davies and Richards and Wallington, and one sees that, paragraphs 98 and following, so it's opus page 23. So this is the first safety valve, if you like, in relation to the 99 deed. That sets out the well-known dictum of Justice Scott. Davies and Richards and Wallington simply asked the court to read that sideline passage to themselves. Now that is a principle which, as you can see, comes from the property arena, so the disposition of property. It's been used in Davies and Richards and countless cases subsequently in a pensions and private trust sphere. The idea is this: if something is needed to be done, you can impute the intention to do it, even though the disponer had no awareness of the power, nor indeed any subjective intention to exercise the power. So in Davies and Richards and Wallington, a deed would only have been valid if one of the trustees who had purportedly remained trustee had concurred in it. It was imputed to the employer the power to remove him as a trustee, to remove that concern. That's Davies and Richards and Wallington. Now on to Shinovich, which is picked up in 107 of this case. Over the page, please, page 20, actually page 25, opus 25. Sorry, if we go back, sorry, I do apologise, to 24 to start there. So we're now dealing with what happened after the 1999 deed. There was a recognition in 2000 that there were errors in some of the provisions of the 99 deed, and there was an informal attempt to amend that. That informal attempt had no effect because it didn't conform with the power of amendment. The argument now is to whether reference in a subsequent deed to the informal attempts to make the correction could somehow validate that previous ineffective attempt to amend. And it's really paragraph 107 where one sees what has been done. So if I just ask the court to read the two lines at the bottom of that page and then on to page 25. So crucially, the 2001 deed did not purport to amend the defective rule 61.4a. It purported to make another amendment, but it refers to the fact that 61.4a had apparently erroneously been corrected in it. And the crucial point is that that recital in the 2001 deed was held to validate the intention to make the change, albeit only prospectively from the date of the 2001 deed. And I would simply ask the court to read paragraphs 112 to 114. When my lords, my lady, ready, we can move over the page. Thank you. Just finish off reading paragraph 114. The next two paragraphs are an analysis of the Royal Court's decision in Re Shinovich. We can pick up again at 117 for the Deputy Judge's assessment. And I rely upon that to show that the precise reason for the ineffectiveness, the nature of the mistake, is irrelevant. Now, these principles, in the three cases we've just taken you through at speed, are clearly analogous to what is going on here. There's much less of an artificiality to what we are considering as to whether there were a declaration of trust in 2019, 2020. Crescent tries to distinguish these cases to say, well, they're to do with the exercise of powers. True they are. As I said, the principles come from the property sphere, and their reach extends to the validity of trusts, deeds. And I say there's no material difference between what is being done there and what is being done now. And the general principle to take away from this is the focus of the court's attention on substance and overall intention, rather than arguments that frustrate such intention. And I say with greatest respect that Crescent's argument here seeks to frustrate the intention of NIOC. That's all I wish to say on these issues.
Thank you very much, Mr. Grant.
My lords and my lady, I'll start with ground one, if I may, which takes us back to section 53(1)(b). Now, I'll address first the text of 53(1)(b), which your lordships and my lady have at AB tab 8, page 1. I should say perhaps if my Lord Justice Zacaroli requires any PDF page numbers, we can supply them if any are needed as we go through. I have been working from Opus numbers myself. Now, looking at the section, what is immediately striking about the section is the stark contrast between the wording of subsection B and the wording of subsections A and C, both of which make express provision for lawfully authorized agents to sign, and moreover specify that such lawfully authorized agents must be authorized in writing. Now, there's no such provision in subsection B, obviously, and it's striking that contrast. It's been remarked on, as the court has seen, by many of the commentators and some of the cases that we'll see. Now, we find section 53 in part 2 of the Law of Property Act. Part 2 is sections 40 through to 84. And what we find about that part is that the legislature specifies when documents may be signed by an agent, and indeed when that agent has to be authorized in writing. Now, section 53 is the best known example, but one sees it in section 40, which as enacted we find at Authorities Bundle tab 6, page 1. 77 in the PDF. This section, as I'm sure the court knows, has been superseded by section 2 of the Law of Property and Miscellaneous Provisions Act 1989, which, like section 40, its predecessor, permits signature by an agent. And section 40, as we'll see, says in the later wording, signed by the party to be charged or by some other person thereunto by him lawfully authorized. It's now, the current version is section 2 of the LRMPA, which you'll find behind at Authorities Bundle tab 16. And one sees the agency point at subsection 3, the document incorporating the terms, or where the contracts are exchanged, one of the documents incorporating them, but not necessarily the same one, must be signed by or on behalf of each party to the contract. So it has makes the agency point, and one knows from subsection 1 that the contract has to be in writing and incorporate all of the terms. Now, the section 40 obviously made provision for agents. You could have an agent sign, and as McGarry confirms, they could be orally authorized. That's in McGarry, Authorities Bundle 167 at page 9. Three, 6. We see, yes, top of page 9, C, agents. The Act requires the contract to be signed by and behalf of each contracting party. There's no requirement the agent should be given written authority to sign. And it makes the point in the footnote 335 down the page. It draws the contrast, the distinction with section 53(1)A and indeed 53(1)C. While we're there, McGarry is one of the texts which opines that agents are not permitted under 53(1)B. It says that in the extract we're looking at pages 4 to 5, so Authorities Bundle 167 at pages 4 to 5. If we're starting at the foot of the left-hand page, the fact that a disposition may be made by an agent should be contrasted with the rule for creation of trust of land, where the signature of an agent is not enough, and the rule for contracts for the dispositions of land, where the signature of an agent suffices even if the agent's authority was given only by word of mouth. Now, the approach of the legislator that I've been indicating is also apparent from section 54 of the LPA, which not only comes immediately after our section 53 and is part of the same part 2 of the Act, but it is specifically referenced in our section 53 and we see it in the authorities bundle tab 8. Sorry, that's the reference to 53. It's in tab 9, it's section 54, which tab 8 is section 53, which we're looking at, obviously. But it's actually probably appropriate to start with the cross-reference that we do find in our section 53. If we could revert to that for a moment, at AB tab 8. It starts, subject to the provisions hereinafter contained, with respect to the creation of interest in land by parole. Now that's a reference to over on tab 9, section 54, where it is headed, as we see, creation of interest in land by parole. And it says all interest in land created by parole and not put in writing and signed by the person so creating the same, by their agents thereunto lawfully authorised in writing, have notwithstanding any consideration having been given for the same, the force and effect of interest at will only. Now, these two sections, 53 and 54, are to be read together in the sense that one is subject to the other. Section 54 provides in terms that a putting in writing may be signed by an agent lawfully authorised in writing. Now, what we get from this pattern, I suggest, my lords and my lady, is that it's obvious with respect that the legislator in these sections is providing expressly for when agents can be used, and if so, when they have to be authorised in writing. My lords and my lady, it's probably also worth taking a brief look at section 49(1), which is in the same part 2 of the LPA, and that's behind tab 7, Authorities Bundle tab 7, page 78, which is on a different subject matter, applications to the court by vendor and purchaser. The vendor and purchaser of any interest in land or their representatives respectively may apply in a summary way to the court in respect of any requisitions or objections or any claim for compensation, etc. Now, I don't claim any immediacy of subject matter here, but one is seeing again in the same part of the Act specification for when representatives can be used. And reverting to our section 53 behind tab 8, it also refers, as we know, to or by his will. Now, 53(1)(b). Now, the will of an agent would be irrelevant. Agent's authority terminates on death, and the will doesn't take effect until death. So it isn't possible for an agent to declare the trust in its will. And we also see that A and C, when they refer to wills, they say and or by will. They don't say by his will, they say or by will. Because his will wouldn't make sense for an agent. His will appears in B, appears to refer to the person who's able to declare the trust. Indeed, in Tierney, that is exactly how the court construed it. If we can go back there briefly, Authorities Bundle 4, tab 122. 2476. We've looked at the Tierney case before. Authorities Bundle 122. There we are. And for this purpose, I wanted to go in the Master of the Rolls judgment to the foot of page 3. We're picking it up 3 lines from the bottom. I think that the fair conclusion to be drawn from these considerations is that the person to create the trust and the person who is by law enabled to declare the trust, pausing there, it is of course under the statute of frauds here, are one and the same, and that consequently the beneficial owner is the person by law enabled to declare the trust. This is confirmed by the expression in the clause in the statute which relates to the last will in writing, which can only apply
So over the page, please.
I beg your pardon, yes, if that could catch up. Consequently, the beneficial owner is the person by law enabled to declare the trust. This is confirmed by the expression in the clause in the statute which relates to the last will in writing, which can only apply to the beneficial owner. I submit that by his will appears to be another indicator that agents are not included in B. Now, I take the point that when you get to companies, companies holding land was less common until 1925. Land tended to be held by individuals, but the LPA is not, I think it's perfect, it's fair to say, a perfect piece of drafting, and it does contain some infelicities, and of course will would not be applicable to a company. But I suggest that nevertheless, the use in the circumstances of by his will is an indication against agency. Now, the appellants argue that on a literal reading of, in our subsection B, some person who is able to declare a trust, that B would include a lawfully authorised agent, they argue. Now, a number of points on that. First, that phrase has to be read in its proper context in the LPA. I don't need to cite the Benyon proposition for that. And it needs to be read in the context of the Act as a whole and its legal and its social and historical context. That includes, of course, subsections A and C of the section itself, as well as section 40 we've looked at and section 54, all of which I suggest strongly indicate the phrase was not intended to bring in agents. Secondly, the appellant's interpretation means reading the section, section 53, such that section 53 1b, which does not refer to agents, is more permissive than A and C, which do refer to agents. Because, of course, on the appellant's construction, that would include orally authorised agents in B. And we submit that is respectfully counterintuitive. I'll develop the position about orally appointed agents because that's quite important in a moment. And thirdly, we say that the construction that's being pressed on this court would undermine the legislative purpose of the provisions, which I'm coming to shortly. One feature of that would be the inclusion of orally appointed agents. And fourthly, we say that the A statute must of course be read and applied in the context of the general body of law into which it was assimilated. And when we come to the authorities, my lords and my lady, we will see that the state of the law as it was in 1925, and indeed remains, is that in cases of transfers on trust, the trustee could provide the proof of the trust. Just to unpack that a little bit, traditionally, I think this did come up yesterday, briefly, a settlor would create a trust by transferring rights to another, a trustee, to be held for a beneficiary. Typically, A transfers to B to be held on trust for C. And if a settlor skipped the transfer bit and simply declared they were holding their rights for a volunteer beneficiary, courts wouldn't give effect to that. That position changed in the early 19th century, and it was established in the cases that a trust could be created by declaration rather than transfer. And the history is explained in the Agnew and Douglas article that Mr. Mumford was recently referring to at the beginning of that article. And the latter type of cases are commonly referred to as self-declaration cases. Now, why does that matter here? Because the authorities could have gone either way or differently, but they went in the direction of holding that in transfer and trust cases, the trustee could provide the evidence of the trust. And why does that matter? Because it means that in 1925, the state of the authorities was that it was not only the beneficial owner or settlor who could provide evidence of the trust, the trustee could do so in transfer cases. And there are some good reasons that are discussed in the articles as to why the trustee should be able to do that. UDAM discusses the reasons I won't go there, but it's at Authorities Bundle 5, page 1, tab 133, page 12, where he notes that a trustee is a person against whom the trust would be enforced, and says that it seems appropriate in those circumstances that they should be able to effect the formal requirement that makes the trust enforceable against them, and it goes against the trustee's own interests and gives effect to the settlor's intention. One could also observe that it would obviously be a fraud for the trustee to claim the property beneficially for themselves where the property had been transferred to them on trust. That's the Rochefoucauld and Bousted doctrine. And the trustee may very well in those circumstances hold the property on constructive trust anyway if the express trust were to fail, which may be another reason to permit the trustee to provide the writing where there's none. But in those circumstances, it may justify the trustee's actions in performing the trust. So in transfer cases, the trustee could do that, provide the evidence. So there was a reason not to confine the writing in subsection B to saying the settlor or the beneficial owner, and which may be a reason why it does not use those expressions. Now, the fifth point, when we come to the law, we'll see that there is no authority that we can find which clearly establishes that an agent may declare a trust over land. It's an assumption that the appellants make, and they cite some authority which actually relates to constructive trusts or trust by operation of law, and even the authorities relating to trusts over personal property do not establish the proposition in any convincing way. Sixth, my lords and lady, one of course recognises that in Gray and the IRC, the court has noted, there's been discussion of this, that the LPA has a complex history. It consolidated a number of amending statutes, and one cannot necessarily draw a straight line from the statute of frauds provision to the equivalent in the 1925 Act, which deals with the same subject matter. As the court said in Gray, the court has to give the words of the LPA the meaning proper to them in their context. That case, as we know, we're reminded by Mr. Mumford, related to section 53(1)(c), and the different wording was determinative in that case. But with that reservation in mind, it ought to be pointed out, and I will point out, that the legislative history in this respect quite strongly suggests that these words did not intend to introduce agents into 53(1)(b). I will take your lordships to that. And it's not a matter of any debatable construction in the cases as to what previous wording meant. It's just looking at the history and evolution of the statutory words themselves. Now, my lord, I was going to move to legislative purpose, which will take more than 3 minutes. While I'll
Do you
note
want a
out
break
that.
then and we'll, how are we doing for time?
I believe we are good for time.
Good, all right. Okay, 2 o'clock in that case.
All rise.